You're smart. You know that stuff.
All right, welcome back. Shh. Welcome back. Welcome back. We start? Thank you. All right, hope everyone's doing well. Any questions before we get started? Anything on your minds? Okay, please sign in to the attendance. It's on right now. I want to start with a question for the poll. Okay. All right. So here's your question. It's multiple choice. So let me make a little bit. See everything. All right. It begins like this. In 2000, B purchased Blackacre from A and receives a general warranty deed. In 2005, C purchased Blackacre from B and receives a quitclaim deed. In 2010, D purchased Blackacre from C and receives a general warranty deed. Then in 2015, E comes along and he reveals that he had purchased Blackacre from A in 1995. So we have a problem. A sold Blackacre to E in 1995, and then he sold Blackacre to B in 2000. This is a fairly common situation where the same person will sell property to, please be on time. Thank you. Where the same person sells property to two different people. Okay? E sues D to quiet title on Blackacre. That is to establish who actually owns it. Who can sue D? I'm sorry, who can D sue for breach of covenant of quiet enjoyment? So the question is, who can D sue? Now we know that A committed fraud, right? That much we know. But our question here is, who can D sue? So we have choice A is A, right? B is B, C is C, D is all of the above, and then E is none of the above. And people always hate the none of the above because it makes them doubt themselves. That's why it's there. All right, take about 30 seconds, and I'll wait for everyone to put their answers in, please. A, B, C, D, or E? Okay, about 30 of you in. Another 10, 15 seconds to put an answer in, please. And this is the sort of question that simulates what you'll find on an exam with these sorts of chains that are somewhat intricate. So I want to make sure you take care carefully. All right, a bunch of you haven't signed in yet. Keep going. Put your answers in, please. All right. Okay. All right. Where did I drop off last? Shannon, you next? Andrew, you went? That's right. I called on someone over there, and that's right. Okay, Laura, I think you're next. Okay, thank you.
Okay, so I got C.
Okay, tell me why I think the answer here is C, Laura.
Oh, because with the general warranty deed, who they purchased it from, they are liable for basically any, how do you say it? Basically anything that happens to the land.
Okay. Okay, very good, very good. Okay, very good. Okay, that's correct. The answer here is C. Let's see what we got. Oh, very good, 90%. That's either you're all cheating or you know the answer correctly. But that's very good. And let me explain why. I think Laura said it well a minute ago. Let's go back to our chain. What we have here is a situation where there are multiple transactions. And how I encourage you to work these transactions is to start from the most recent. Start from the most recent. So we see in 2015, E reveals that he purchased Blackacre from May 1985. Okay. Next one. In 2010, D purchases from C, and there's a general warranty deed. Without question, D can sue C for a violation of what's called the covenant of quiet enjoyment. And the covenant of quiet enjoyment means if someone comes along and claims, like E did, that he owns it, that the guarantor, the person who gave the deed, will back it, will stand behind it, can be sued. Okay, so without question, D can sue C. Now, C right now must be feeling not so good, right? C's like, oh man, I have to deal with this lawsuit. Let me see who I can sue, right? Let me see if someone else can cover my rear, right? But what happened is that when C bought Blackacre in 2005 from B, what kind of deed did C get? Quitclaim. And a quitclaim deed is unique in that there are no guarantees. In other words, B sold it as is. So B's by himself, right? B's not involved with this at all, okay? Now what about A? A gave B a general warranty deed. But by putting a quitclaim deed here in the middle, it breaks the chain. And that's an important concept. When I say break the chain, what do I mean? You need to have a continuous row of general warranty deeds to sue all the way up. Had B received a general warranty deed, then the answer would have been all the above, right? Had B gotten a general warranty deed, had B given C a general warranty deed, you could have sued all the way up to A. But because you have this quitclaim in the chain, it breaks the chain. Okay, so the answer here is C. Very good. That wasn't so bad, was it? Okay, good. All right, any questions on this? Yes, Bina.
If it wasn't a quitclaim deed, say if there weren't any quitclaim deeds, all of the deeds were a warranty deed.
Yeah.
Then D can sue C,
Yeah.
D, and A?
Yeah, let me just change it for a second. I want to modify it to answer your question, okay? Let's say this was a general warranty deed in the middle. Then the answer is all the above. Because what would actually happen is, think of privity, right? E would sue D, D would sue C, and then they would bring to litigation B and A, right? They'd all be in the litigation. It's technically like in pleading, if you want to think in civil procedure terms, right? But you basically drag in all the necessary parties. In reality, what's happening is A's insurance company is covering the bill, right? It's not going to be A, but whoever wrote the general warranty deed here should have known that there was another transaction. Okay, that's correct. But yeah, go ahead.
If it was a special warranty, then it could have been B and C, but not A.
Right. So the special warranty deed is at like one in the middle, right, where it's not everything but it's still something. It would depend what the warranties are. So let's just say that the special warranty deed had the quiet covenant, the quiet enjoyment covenant. Then it's fine, right? But let's say it's like a more obscure one, like only the covenant to provide documents, right? That's not really important. Then E comes along, that doesn't matter. So you have to have basically the same covenant running up the chain all the way. Make sense? Yes, is that a hand? I thought so, a hand, okay. Yes, sir, Andrew.
So under the original version, who can sue A for fraud? Is it just B?
Okay, so this is an important point, right? I think at this point, B could sue A for fraud, yeah. Because when E purchased Blackacre in 1995, there was no fraud. He was the lawful owner. B would have the claim for fraud. So not only is B not in the hook for damages, B could also go after A for fraud. I think that's right. Right, again, in this class, I don't care about fraud, and it sounds awful, but I only care about property stuff. Like, can you cancel the sale? Can you be liable for quiet enjoyment, right? Whether you can sue for damages for fraud, that's fine, but that's not going to give you specific performance, right? That's not going to rescind a contract or anything like that. Okay, good questions. Yes, sir. Grant.
So when you said there was a continuous general warranty, if that was the case, you said it doesn't break the chain.
Yeah.
So E at the bottom, they can sue just the person that they bought it from, or they can sue all the way up?
Okay, so it's actually multiple steps. So remember the concept of privity, right? In this case, a C and D are in privity, right? D could sue C. And what that ends up happening is that C would sue B and B would sue A, right? Because they're in privity. By the end of the case, they're all in the parties, right? They're all basically suing each other, right? They're cross defendants, if you want to use the technical language, right? But D can't cut to the chase and sue A directly. It would have to do this sort of intermediary level litigation. Make sense? Yes, Emily?
So does E really even have a claim though if they let
Well,
that amount of time pass?
well, I didn't raise adverse possession here, but I could have.
Okay.
Right? And in fact, to be perfectly frank, you now have, what, 15 years. Well, let me ask you, Emily. In the suit to quiet title, who would prevail here?
I guess it depends if the
Let's just say the limitation period's 10 years. I'll give you the limitation period's 10 years. And then you have B there from 2000 to 2005, and C there from 2005 till 10, and 10 from 20, you basically have this chain. Who would own Blackacre by the point of 2015?
can you tack the time?
You tell me. Can you?
If you can, I think D would probably win.
Well, how do you know if you can tack the time? That's the question I'm getting at, by the way. Good review, right, Tony? Privity, which is a magic word, right? Privity lets you sue each other, but also lets you tack. And Tony, is there privity here between B and C and D?
Yes.
I think there is.
Wouldn't it also matter on their mindsets, because don't they have to have the same mindset?
Right, yeah. This wasn't an adverse possession question, but let's just say it was the state of mind's irrelevant. Let's just make it easier, right? It's the English rule where state of mind's irrelevant. At this point, by 2015, I think D is the right, would have the strongest claim. I don't think E would prevail, right? Assuming that it was open and notorious if this stuff is satisfied, E sat around for 15 years while people were living on Blackacre that was supposed to be his. And at this point, I think he loses it. But even if the court awards damages, even if the court awards property to D, that's still a breach of the covenant, though, because someone came along and bothered him. And that's why you need damages, right? In other words, even if D is the rightful owner after the adverse possession suit's litigated, D would still sue C for damages in the breach of the covenant of general warranty deed. So the question of who you can sue is separate from who the owner is under adverse possession, but it's related. Good question. Emily, I'm glad you asked. It was my next thing, my notes saying ask about adverse possession, and you just did it like 5 seconds early, so perfect. Okay. Other questions on this quiz? All right, good, very good. All right, let's move on to today's material. Today we continue a discussion of deeds, and again, keep in mind that deeds and title are different. Title is the legal relationship between a person and a piece of property, whereas the deed is the instrument. It's a document that conveys the title. The first topic might sound straightforward, but it's not. Delivery. You probably remember from Property 1 the concept of delivery, right? When you want to give a gift, where you have to have the right intent, and you have to actually give it. You have to actually deliver it, right? If I say, hey, I'm going to give you this cup, and I don't give it to you, you don't have the cup, right? Now, there are ways around it. You might remember symbolic delivery. Remember that, where you can give someone a key to a dresser, or you might have a case where someone gives you a document describing an item, constructive delivery. There are various ways to deliver stuff without actually delivering it, but you still need some act of delivery. The rule for gifts works the same with the rule for deeds. To convey a deed, to do the deed, if you will, you must give it with the intent that you are giving it in the present, right? If I'm conveying Blackacre to someone, I hand them the deed and I say, here, Blackacre is yours today, right? If I say, here's Blackacre, giving the deed you can have in 15 years, right? That is not delivery. Why? Because it can be revoked. You can take it back. If you can revoke a delivery, it's not delivery. Now, maybe you do something differently. This is very common with houses, right? This past year, I put down a deposit on a house. At that point, the seller gave the deed to what's called an escrow, which is like a third party. They hold on to it. And the escrow holds on to the deed. And when I sign all the paperwork and everything's financed, everything's fine, then the escrow gives me the deed. that is still good for delivery because it's understood you are giving this as long as X, Y, and Z are satisfied, right? You have a present intent to give it. And this is a fairly common way of transferring property. But the key point is you still have to have the intent to convey it now, not at some point in the future. Now, oh, sorry, is that Morgan? Was that a hand up?
No.
Oh, sorry, you're giving me a hand. Okay, that's all right. Now, why does this rule about delivery make a big difference? The reason why is because of death, right? Death complicates everything in property. A lot of people don't have wills, right? They're complicated to write. They require you to make hard choices. And people say, why do I have to worry about it? I'll be dead. What do I care? I mean, it's kind of arrogant because when you die without a will, you give your loved ones a lot of difficulty. They have to take care of a lot of steps. I mean, you see these celebrities die without, I think Prince, right, die without a will. And all these really wealthy people die without wills, and it just creates all these headaches and nightmares for people. Okay? But let's just say you have a house, and you want to leave that house to your son. You don't like your daughter very much. You want to leave it to your son. If you draft a will and your daughter finds out, she may not be very happy about that. It's like, hey, Dad, why'd you leave me out of your will? What the hell, right? What's going on? So instead, you might say, okay, let me try and avoid the will process. And let me give the deed to my son now with the understanding that I stay there for life, and then he gets it when I die. You can do that. Right? What's that called? Hannah, you next? Okay, what's that called if I say, I give my son the house after I die, but I keep it for life? What do you call that?
Isn't that, it's like cause mortis or something?
No. You're alive and well. You're healthy and happy. But you say, I'm going to keep the house for my life, and when I die, it goes to my son.
Wasn't that just like putting your will in a sense?
No, that's not putting in your will. What do you call that from Property 1?
A life history?
Someone whispered it. Yes, I don't whisper. It's not fair to your classmates. It's a process. You're extracting answers. Life estate, right? If a father wanted to say, look, I will keep this for my life. When I die, it goes to my son. My son has what we call the remainder, right? These exist. In fact, recently, you might remember Hugh Hefner, the Playboy guy, right? He basically sold his home but retained the life estate. So it would be the Playboy mansion for his life, and when he died, someone else got it. And he died, I think, a couple years after that estate was conveyed. Now, sorry, that's Kyle. What's the downside of chopping up your estate and putting a life estate in a remainder? Why might you not want to do that?
Because it makes it, well, you couldn't sell it.
You can't sell it. So let's just say, let's say the father is in his 50s and his son's in his 20s, right? You say, look, son, I love you so much. I want you to have this property when I die. Oh, thanks, Dad. So I'm going to give you a remainder of the life estate. And let's say the dad falls in hard financial times and he needs the money. Can he sell a house with only a life estate?
It could, but it'd be worth very little.
It would not be worth very much. So when you chop up your property and you basically retain a life estate for yourself, you reduce its value by a lot. And people don't always know what might or might not happen. So to avoid that problem, a lot of times people do something a little bit funky, where they pretend or they act as if they're giving someone a life estate, whereas they're giving them nothing in the present. What they're giving is a gift after death. A gift after death. And there are two terms that I'm sure you've read before, right? There's a testamentary gift, and a gift I can't spell today. Inter vivos, right? A testamentary gift and a gift inter vivos, or inter vivos gift. You'll see it either way. Andrew, do you remember the distinction between a testamentary gift and inter vivos gift?
A gift inter vivos is a gift while alive, while a
Good.
testamentary gift is a gift at death.
Okay, very good, Andrew, right? If I go and I give you this cup today, this is a gift inter vivos, it's easy, right? All I need to show is that there was present intent in delivery, and that's a gift. That's fine. Tony, in order to give a testamentary gift, what do you have to do? There's some additional stuff that has to happen.
It's in anticipation of death.
No. Yeah, well, oh yeah, I mean everyone dies, but in order to give a gift after you die, what do you have to do when you're still alive? You have to satisfy the Statute of Wills, right? Which generally means you have to have a writing. Generally, when you want to give a gift that takes effect after you die, you have to satisfy the Statute of Wills. Every state has a different statute, but they're all more or less similar in the basic level. You have to have a writing. Why? Because when you're dead, you can't come back to talk about it. Unless you're Tony Stark. Did anyone see the Avenger Endgame? An actual holographic will, right? You know what a holographic will is? A holographic will, I was like, oh my God, it's a holographic will, right? A holographic will is basically a will that doesn't meet the formalities of the Statute of Wills. It's like handwritten, whatever. And yet, Tony, oh, did I ruin the end of the movie? Oh, crap. Oh, I'm sorry. If you haven't seen it, it's your fault. Actually, I didn't like it. I watched it. I flew to, I was in Australia last week, and I flew to Australia, and I watched it on the flight. I was disappointed. I was expecting so much more for the end game. It was boring. I was let down. I like Back to the Future timelines better. I don't understand the Avenger timeline for time travel. I don't get it. I'll take Doc Brown over Hulk any day. I didn't get it. It didn't make sense to me. But anyway, there was actually a will that was projected as a hologram, so it was a holographic will. I'm breaking your heart. He doesn't have his own movie. Anyway, but generally, to have a testamentary gift, you need a will that's in writing, and has to have witnesses, right? It has to be signed by 2 witnesses. There's a lot of formalities that go into it. You can't just have like an oral gift. And it makes sense, right? When the person's dead, they can't come back to tell you what they intended. So you need something in writing. Now, this is why this topic is relevant. If I give you a deed today and say, look, I'm giving you this deed today, but I don't want you to have it now. Just hold on to it for a couple of years, and then after I die, it's yours. That is not an inter vivos gift. That's a gift that's testamentary. And because there was no writing conveying that intent, and there's no witnesses who sign it, it's ineffective. Right? You probably had a case last semester, though, similar, where the father gave a painting to his son. Remember this one? It was like, here, son, I'm giving you this painting, but I'm going to hold on to it, right? People do this a lot to avoid taxes and all these other sorts of things, right? If the father actually wanted to give the son the painting, he would give him the damn painting. But by holding on to it, it's suggesting maybe he wasn't actually giving it to him. That case is weird. They said that the father basically gave the son a remainder. It was a weird case. But the idea is, if you give something to it now, it's yours. Okay. So let's go to the first case, right? Rosengrant versus Rosengrant. Just as a rule of thumb, whenever you see a case where the first name and the second name are the same, it's a family dispute. It might be a divorce. It might be a custody battle. Here, it's a dispute between a bunch of ingrate nieces and nephews. Did I say that out loud? Sorry. Yeah, this does not seem like a very happy family. When this stuff goes to court, and like there's secret deeds and vaults to keep people out of it, this is not a functional family, right? Things are not working right. Who is that? That's Grace. Grace, you want to give me the facts, please, in Rosengrant versus Rosengrant? Okay, so just let me pause you right there. When a person dies without children, the Statute of Wills has a fairly elaborate formula of how the property split up. And if there are no children, there are no parents involved, then they start going out, right? Brothers, sisters. If there are no brothers and sisters, then they go nieces and nephews. So in theory, at least, there were, 5 or 6 nieces and nephews? All of them would have had a stake to the farm, right? They all would have inherited some share of the farm. And of course, they don't have to split it. They can maybe just sell it and split the money. But by virtue of dying intestate, that is dying without a will, each of those kids would have had a share of the farm. Now, as we'll see, Harold and Mildred tried to cut out the other ingrate nieces and nephews. It didn't help them. All right, go on, Grace. Continue, please.
So, Mildred got cancer, and one of the nephews died.
Yeah. The good one.
came
Yeah.
to help her out, and in consideration of this help, they wanted to give Jay their farm.
Okay, so let's just, okay, Grace, that's right. Morgan, let's just walk through. Okay, so we have Jay, who's the good nephew, and his wife. They care for Harold and Mildred, right? And they go with her to Mexico for treatment, and they're very, they're loving nieces and nephews, right? How does Harold and Mildred try to, I don't use the word compensate, that's the wrong word, reward Jay for his, good behavior?
So they say that they're gonna give him their farm that they live on.
That's what they say. What exactly do they say?
Like exactly what they
Yeah, let's walk me through the details. There's a scene at the bank that's kind of, the concurrence doesn't think it actually happened, but let's just pretend it happened for a minute.
So at the bank, Harold and Mildred does sign the deed, and they told Jay that they were going to give him the place.
The place. When? At what point?
What?
When would they get it? They
After both of them divorced
did they actually say when they died? They something.
when something happened.
Yeah. Okay. So there's like, if something happens to me, it's yours. All right. So Morgan, what's the problem with that sort of language? Why is that just that language by itself problematic?
So it's not like a present intent to transfer the property at the time.
Yeah. So it's fairly obvious what's going on here. Harold and Mildred do not want to write a will, right? They don't want to make a public document that leaves out 5 of the 6 nephews and nieces, right? So Elliot, why doesn't Harold and Mildred just give Jay the property now in fee simple, or give him a remainder and they keep a life safe for themselves? Why don't they just actually do what they say they're going to do?
They don't want to offend their rest of the nephews?
Well, if they give a remainder, they would never have to know about it. Why don't they just give them a remainder and keep a life safe for themselves? Why doesn't Harold and Mildred just do the right thing and give him a remainder? So when they die, it's his in fee simple.
So they don't know what they're doing?
Oh, I don't think I think they know what they're doing. I think that's the problem. Jay doesn't know what they're doing, but Harold and Mildred know exactly what they're doing.
So they're just going to tell him that he gets it?
No, but why don't they give him a remainder? There's a reason why. Elliot, what happens if they give him a remainder? What happens to their property?
Decreases value.
Decreases the value. Look, Mildred's sick. What if they need to mortgage it, right? What if they need to take out a loan on the property? So they basically pull a fast one on Jay. And I don't want to say that they were deceiving, but it's close, right? They went through this entire elaborate ritual where you take the deed, you hand it to the banker hands it to me, I hand it back to the banker. It's just worthless. What they're doing is nothing, right? There's like no value in this little charade that they're doing. But the key part here is they didn't give it to him with a present intent. Indeed, Zach, what did they write on the envelope of where the deed was being? Oh, did I skip someone?
Yeah, you skipped Grant.
I'm sorry, the name tag was in the wrong spot. Grant, let me call on you, but I appreciate you willing to answer, not throw your guy under the bus. Grant, what was written on the envelope where the deed was kept?
It had their name for the
What? Just give me the quote. Just what did it say?
J.W. Rosengrant or Harold H.
Or. Okay, Grant. What's the significance of that word or?
You can't have an intent to give it to one person if there's 2 names.
Who can retrieve the deed?
Either of them.
Yeah. At any point, Harold could have gone to the bank and retrieved it. Right? That's a significant fact. Even though they say here, this makes it legal, that's oral. Spoken words does not satisfy the statute of frauds, right? If I say, I'm giving you this property, but the thing says I'm not, the writing controls, right? The oral conveyance is not enough to convey this property. For real property, you need a writing. And the writing, what was actually in writing, said or, and that was such an important word. Because we don't know what happened at that bank. The concurrence is kind of funny, I'll get there in a minute, but the majority at least recognizes the facts as pleaded. There was not an intent to convey it presently. Because at any point, Harold could have come back and seized it. All right, I understand. All right, so what happens, right? Eventually, they both die. And then as soon as Harold and Mildred die, all the other nephews pop up at the work. It's amazing if you have a death in your family and there's money to be had, that these long-lost relatives just appear magically as if, where have you been all this time? But they're there. They pop up. And, okay, Zach, what does the lower court hold here? The trial court.
They held that it was invalid because of the delivery.
Okay. Oops. 1 second. Huh. 1 second. A second. Sorry about that. Okay. So the trial court holds that the delivery was not with a present intent. Why? This was not a gift inter vivos. It was considered a gift testamentary. Okay? And then, so Zach, what does the appellate court do? They affirm or the reverse?
They affirm.
Okay, on what ground?
They looked at. They said that there was a clear implication that he didn't want to give away the whole thing, that he still could come back and take the deed if he needed it for some reason.
Okay, very good. Here's the rub, right? Because there was no present intent to convey the property, this was not a valid delivery. Even though Jay and his wife were lovely nieces and nephews, there's nothing in writing that would satisfy the statute of frauds that would make this conveyance valid. Right? At any time, Harold could have come back and claimed the property for himself. Therefore, there was no valid conveyance, and therefore they died intestate. And because they died intestate, the statute of will dictates how the property is divided up. And in that case, all 5 or 6 of the nieces and nephews can get a claim to the land. Okay. Everyone with me? All right, very good. Natalie, what did the concurring opinion say? It was short, but I think it's worth discussing.
So the judge agreed with the outcome, obviously, but he did not agree that there was no delivery.
Well, what was the concurrence skeptical about? The concurrence was very skeptical. It was a little sarcastic almost.
Well, says the law is clear, actual constructive delivery of the deed to the grantee or to a third party, and an intention by the grantor.
What was the concurrence skeptical about?
Whether this could have been a life estate.
Natalie, who was present in the vault at the time?
The grantee, the Jay,
Who else?
his wife, and the 5 nieces and nephews.
No, that's not right. Mackenzie, who was actually present in the vault when this happened?
The banker.
And who else?
The 2 dead.
Okay. Okay, so of the people who are in the vault, who's still alive? Only Jay. All right, so what is Mackenzie, the concurrence skeptical about?
Didn't they talk about how Jay worried about Jay's honesty? Or
Yeah.
if there's actually true evidence?
Yes. Okay. The concurrence is very, very skeptical that this actually happened, right? The concurrence doubts this actually happened. In fact, the concurrence basically calls Jay a liar. Yeah, everyone know what the phrase self-serving means? You'll see this word a lot. Self-serving means when you say or do something that really benefits yourself. And when you say something that benefits yourself, there might be reason to be skeptical if it actually happened. Right? Skeptical that it actually happened. So he doesn't quite call him a liar, but I think he comes awfully close. All right? And he says, you know, why didn't Harold just convey the property straight up? Right? And that suggests that he didn't intend to give it to Jay. Right? Everyone's kind of tricking each other. So we don't know what exactly happened, but the concurrence is like, this is probably not what actually occurred, as Jay told it. The facts were too perfect. They were like too neat and clean. Okay. All right, so the holding then, right, of this case is that delivery was not valid because this was a testamentary gift that did not satisfy the statute of wills. You have the writing, you have the witnesses, you have the requirements, other formalities. Okay. All right, questions in the first case? Anything? Yeah, Stephen.
Ultimately, it was because there was a right of reentry or return because both people's names were on the will or the envelope that contained the deed.
Uh-huh.
Sorry. The envelope that contained the deed had both the grantee and the grantor's names, so either one could retrieve it at any time. So therefore, it was more like a inter vivo. Is that correct?
Okay, so it's actually the or for sure. Let me say it like this: the fact that the word or is there means it was not an inter vivos gift. But what was it, right? What do you call it when I say, okay, I'm going to leave this deed here, and either I can take it or you can take it? What is that? It's not a gift because it's not a present tense convey. This wasn't in the case, but if you asked me the or, it was irrelevant. It was nothing, right? I think it'd be ambiguous as to what the intent was. Would not be valid as a gift of any kind, right? Like Stephen, I can't say, look, I'm going to give you this phone, or I'm going to take it back. Like, what the hell is that, right? It's whoever gets to it first, right? I suppose you could say whoever goes to the bank first gets it, that kind of thing. But they're both right there, so it doesn't really make any sense. So I don't even know what the or gift would even be. I think it's nothing. I think that there's no conveyance at all, even for the intent was there.
So legally, just void.
I think what the entire incident in the bank was just utterly irrelevant. Like, you know, these are people either who were not sophisticated or the people who were deceiving each other. I'm not sure which one it was. I mean, Uncle Harold might be smarter than he looks. You know, maybe he knew exactly what he was doing. Think of it this way, right? They got all this free care. He may have just been like doing this to try and keep the guy on the hook. He's like, here, see, if you play nice with me, you get the house, but maybe I'll take it back if you're not nice. You know, it could have been something like that. We don't know.
But he still paid the taxes on it. I mean, then he got
because he thought it was his, right? It could have been, look, if you guys keep helping taking care of us, I'll leave this in the bank. And if you stop taking care of us, I'm going to take it back. It's going to be mine. I mean, that's plausible. I don't know. Maybe that's what happened. Okay. All right, any questions in the first case? All right, let's go on to the second topic, which is mortgages. And I want to get terminology straight because the terminology here often confuses students. Okay. Is that Matt?
Yes.
Matt, what is a mortgage?
Mortgage is an interest in property for someone that, say, is giving you a loan. It puts them first in line should you default on payment.
Okay, you're exactly correct, but specifically, what is a mortgage? How would we define a mortgage? I think you told me correct things, but what exactly is it? You said interest. Give me more on what that means.
you've given a portion of your interest in the property.
Use interest to find interest, right?
Yeah, you've given
Yeah.
you've given them some claim to the
Okay, that better. Okay. The idea of a mortgage, I like to use the word security, right? If someone's giving me a boatload of money, right? I take a loan out for $1 million. They're not doing it because I'm a nice guy. They're doing it because if I fail to pay, they have some remedy, right? So if I take out a loan of, let's say, $100,000, I give the bank a mortgage. Wait a minute, doesn't the bank give Josh the mortgage? No, 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 no. I give the bank the mortgage. And in exchange, the bank gives me money. Right? That's how it works. It's the opposite of what you think. So, oh yeah, the bank gave me a mortgage. No, 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 that's not accurate, right? Who's giving what? Josh, the buyer, is giving the bank the mortgage. I'm giving them an interest or a claim or security in my property. And in exchange for that mortgage, they're giving me a lot of cash. But they're not actually handing me like a suitcase full of bills, right? That's not how things work. They give you what's called a promissory note, which is a term you probably know from your student loans, right? Right? You get a promissory note. Okay? So I want to just look at these two words, like mortgagor and mortgagee. Ethan, let's see if you remember. Which is which?
The mortgagor is the one that takes out the loan, and the mortgagee is the one that has the interest from.
Okay? Okay, very good. The mortgagor is the borrower. I can't say that word, I'm sorry. The borrower. It's a hard word to say. The mortgagor is the it's a tongue twister. The mortgagor is the borrower. Okay, got it. Good. Okay, and then Ethan, again, who's the mortgagee?
Is the one that's got the interest in the property, the one that's
The lender, right? The bank, right? Okay. Now, the reason why I want to show you these terms is the endings, right? Morgan, do you remember the difference between the OR and the EE? Remember I gave this one last class, I think, or the class before? Right, and then what does me do? What me, I? Okay, what is the mortgagee receiving? Yes, exactly, the mortgage, which is a security. Perfect, right? The mortgagee is the bank. They are receiving the security, the bank, of the mortgage, right? That's the interest in the property. And Morgan, finish it up. What's the mortgagor giving?
Mortgagor is giving money.
No, 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 no. Who's the mortgagor?
Oh, the borrower.
And what does the borrower give in this case?
They're giving an interest.
They're giving the mortgage, the security, right? Please do not confuse these terms. You will in the exam, I promise you. I know you will because I've done this before, but try not to. The mortgagor is the one who gives. And what are they giving? They're giving the mortgage, the security. Everyone says, oh, of course, the mortgagor is the bank because the bank gives the mortgage. But it's the other way around. The mortgagor is giving the interest. The bank is receiving the interest, the security, right? Everyone with me? Okay, so when the mortgagor gives the interest, in exchange they get the money, right? It's called a promissory note, right? The promissory note, as the name suggests, is a promise to pay back money. I'm sure all of you have, or hopefully most of you have student loans, I'm guessing, right? I finished paying off my loans last year. God, it took me almost a decade, but I got them all done. It's a good feeling when you get there, but it took a while. It's funny, I made my last student loan payment the month before I got my mortgage. So like my credit was like zero lot. You know, it was just like this like brief period where I had no debt, and then it went right back up. It's how it works. Okay. Okay. Now, when you have a mortgage, you have the promissory note, and you have to make monthly payments. And let's say you make all of your payments on time. At the end of 30 years, they actually give you the note back, right? And that means you have it. You have the paperwork. It's yours, right? You don't have any more obligation. Okay? Okay, everyone get the terminology. You got the mortgage. You have the note. They're different things, right? The bank is giving the note. The buyer, the borrower is giving the mortgage. Please don't confuse them. Easy way for me to test you if I get terminology right. Okay. Let me talk for a minute about the actual process of getting a mortgage, a little bit practical stuff that might come into your might come into your life. Generally, if you're looking to buy a house, one of the first things you do is pre-qualify. What does that mean? You go to a financial institution, you say, I am looking to buy a house. How much of a loan will you give me? How much of a loan will you give me? That number will be based on your income, on your credit history, on if you have any debt. Perhaps you have a cosigner, maybe a spouse or a parent. There are lots of factors, but they'll eventually say, here's how much you qualify for, say $500,000, whatever it is. That doesn't mean you have to spend all $500,000. You might take a loan for much less, but you qualify for the maximum amount. Okay? All right, so you go, you pre-qualify, you buy the house, you give the bank the mortgage, and you have this promissory note. And let's say it's a 30-year mortgage, fixed rate, which is more or less standard today. Who's next? Sorry, Ashley. Ashley, during the 30 years in which you're paying off your note, again, you're not actually paying off the mortgage, although those comics say, I'm paying off my mortgage. No, you pay off the note. During the 3 decades in which you're paying off your note, who actually owns the house? Oh, what a good answer. I love that answer. Okay, tell me why it depends. It's a very good law school answer.
Depends on if it's a majority view or minority view.
Okay, so tell me, what are those 2 views, please?
The title theory
Okay.
is the minority view, and the bank takes the legal title to the property until the loan is paid off in full.
Okay.
And the majority opinion and Texas view is the lien theory.
Lien theory.
Mortgagor retains the title subject to the bank's loan.
Okay, very good. You just answered like 4 questions in a row, so it lets me save time. That's very good. There are 2 general theories that the states implement, right? There's the title theory, and there's the lien theory. And this is L-I-E-N, not like a lean cut of meat, right? It's L-I-E-N. And the word lien is kind of a weird word, but it just means like an interest or security, right? Okay? The idea is someone else has a interest in my property. So, give you an example, right? Let's say maybe you don't have a house, but let's say maybe you have a car payment, right? And you're buying your car in installments. Okay? And then you pay off your car. That's great. But then you have another debt which you don't pay. Can your creditor come after your car? Maybe, maybe not. But with a house, let's just say that you've been paying off your mortgage for a number of years, and you have a bank, say Bank of America, whatever. You have a mortgage with Bank of America. And let's say you stop making your payments. The bank is going to try and get its money back. But usually when a person falls behind on their bills, they don't just fall behind on their mortgage. They fall behind their other bills too. So let's say you stop paying your car payments, you stop paying your credit card bill, you stop paying your credit card statements, right? You stop paying your vacation expenses, whatever it is, right? And then you have all these creditors, right? You have Verizon, you have Ford, you have General Motors, right? You have all these people who say, I need money from Josh. And I say, peace, you guys, I'm going bankrupt, right? I'm just going to declare insolvency. I can't pay all these debts. All I have is my house. That's all I have. What happens then, right? Who gets first in line? And this is the concept that's often called security or secure transactions, right? How do you prioritize your creditors, right? I'm a debtor. I got my house, that's all I have. And I have these like 8 different companies that want money from me. Who gets to go first in line, right? one of the important aspects of a mortgage is that you're first in line. If you're Bank of America and you gave me a mortgage on the house, you go first. You take whatever the sale of the property gets. If I'm Verizon Wireless or whatever, or I'm cell phone bill, I am probably not first. The reason why is that the mortgage is called secured credit, right? It's secured. You're prioritized. You're in line. You'll take an entire class on secure transactions. So this is just a little preview. But the entire purpose of the mortgage is to give the bank security, so in the event of a conflict, they're first on line. Everyone with me? Okay, so if the bank has a sort of strong interest, what exactly does that mean? Well, we have these two theories, right? Under the so-called title theory, right? This is the first one that was mentioned a moment ago, right? Under the so-called title theory, the bank actually owns the property, right? Throughout the entire 30 years of the mortgage, the bank owns the property. The buyer can maybe redeem it later if he pays off his note. But during that entire time, it belongs to the bank. This is the minority view, and it's sort of harsh. The better view is what's called the lien theory, where the buyer has title to the property, but it's subject to the secured credit, right? That throughout the entire 30 years, the buyer retains title, but the bank is a secured creditor. He has a lien on the property. And indeed, Texas has the lien theory model for your own reference. Okay. Practically, it doesn't make a huge difference, but linguistically it does. So any questions on the title versus lien theory? No? Okay, very good. All right, Bina, walk me through what happens if a person fails to make payments on the note. What happens in that case? Okay, what's foreclosure mean?
It's a proceeding where the mortgager was ordered to pay within a given period.
Uh-huh.
And if they don't pay within that period, then their property is taken by the mortgagee.
Well, is it taken? What happens to it?
Well, they sell it.
Who's they?
The mortgagee.
Who's actually holding the sale?
The mortgager.
Who's actually hosting the sale?
By the court.
Well, often the government's holding it, right? The county holds it. All right? But let me just walk through this one step at a time. At common law, initially, right? At common law, initially, you had title theory, which meant if you fell behind your payments by 1 month, guess what? You lost your house, right? You lost your property. As you can imagine, that was very harsh. Courts of equity, were called courts of chancery, began to soften the foreclosure process. They softened it. And they said, well, even if you fell behind, we will give you some period of time to redeem your equity, right? To pay back what you owe. And then over the years, it moved from sort of an equitable remedy to one of statute. And now in most jurisdictions, you have a statutory period where you have so many days, whatever 90 days it happens to be, to repay it. And if you fail to, the county puts it up for sale. And the reason why it's a government is sort of like a third party, right? But you have these foreclosure sales. But there's a problem, right, with these sorts of foreclosure sales, right? Elizabeth, what's the conflict of interest that exists at these foreclosure sales? There's a conflict of interest that exists in these foreclosure sales. What is a conflict of interest?
The person that's placing the bid on the property.
Well, who's usually, let me put it this way, who's usually placing the bids?
The person who has the mortgage.
The bank.
The bank, yeah.
Okay. And who usually decides what price to accept?
The bank.
The bank. Right. That's the rub, right? The bank is one who accepts the price, and the bank is one who makes the price. Now, other Elizabeth, right? What happens if, let's just say that there's a foreclosure sale. The debt owed is $100,000, and the foreclosure sale only brings in $50,000. What happens there? And what happens if there's such a deficiency? Oh, okay, so we have an anti-deficiency statute. They go after the borrower, right? Let me get one more question. We'll do the questions on 622 in a minute, but Dakota, let me ask you this question. What happens if a property has two mortgages on it, right? Two banks. And let's say bank number one has a, go to problem number 1, please, on 622. Here, right over here. So let's look at this one, right? In this case, a house is purchased for $200,000, right? Down payment of $20,000. They borrow $150,000 from the first bank, and see what it says, a secured note. So bank number 1 gave $150,000. Bank number 2 gives a note of $30,000 secured. Right. So they took out a total of $180,000 in debt, and they put $20,000 in pocket. Okay. Now Dakota, the question tells us the foreclosure sale brings in $100,000. How should that money be divvied up? Yeah. So if you remember, bank number 1 lent $150,000, but the sale brought in only $100,000. So all $100,000 goes to the first bank. What can bank number 1 do also, Dakota?
They can also for the deficiency judgment.
Yeah. A deficiency judgment is when a foreclosure sale comes up short, right? I'll show you the Texas deficiency statute here, right? It's linked on the class notes. If the court determines that the fair market value, right, the fair market value is greater than the sales price. So let's say that the fair market value of the house is $200,000, but the sale only brought in $100,000. The persons against whom recovery of deficiency is sought, that just means the borrower. That's a complicated phrase. Okay? Are entitled to an offset against the deficiency. So in other words, the bank can go after the borrower for the difference between the market value and the sales price. Now, just take a step back. That has to suck, right? You just lost your house you were foreclosed on. And because whatever real estate conditions, the sale didn't bring enough money. So now the bank's coming after you for a judgment on top of losing your house and all the fees associated with it. Let me tell you, these are not very popular. And they're also not very successful. Why? Generally, a person who's got foreclosed on doesn't have money to pay a judgment, right? They're not going to pay. A person who just lost their house is in probably a bad situation. No one loses their house willingly. And going after a person for this is sort of like kicking a person when they're down. So banks don't always do these, but they can. Right? They can go after people for deficiency judgments. But the courts are very skeptical about enforcing these because, again, people aren't going to pay them. Also, these are not secure debts, right? If someone fails to pay this $50,000 debt, you can't collect from them, right? You don't have a secured a mortgage to collect on. All right, so questions on that? Let's go back to our question. Oh yeah, Andrew, go ahead.
Okay, so yeah.
I didn't get to the second bank yet. That was my next question.
But the $100,000 going to the first bank, that what the first bank gets would be offset by the amount of equity that's already in the house, correct? So, like, they wouldn't be entitled to the full $150,000 if they'd already paid some money in equity.
Yeah. So this question. This question assumes there's zero equity.
Yeah.
Okay, so let me address Andrew's question. You're trying to make it more complicated, but I'd be happy to, right? If there's only $50,000 left in the mortgage, they can't keep all $100,000. But in this question, assume that there's $100,000 left in the mortgage. Assume they never made a single payment, that they bought the house and they made 0 payments. Okay? Alexis, what about bank number 2? Right, bank number 2 is owed $30,000. Do they get anything from this 100?
No.
What does bank number 2 have to do to get anything?
Would they do a deficiency judgment?
So here's the rub, right? The money, the $100,000 goes to bank number 1. What does it mean when you foreclose? All right. What happens to the mortgage after the foreclosure?
It goes to the bank.
Does the mortgage still exist at that point?
Oh, no.
Okay. The second mortgagor, the second mortgagee, the bank, is out of luck, right? They don't get a penny. And that's one of the risks, right? That's one of the risks of being an unsecured creditor, right? When you give a second mortgage, you have to recognize that you may never get a penny back from it if the first mortgagor collects everything, right? Now, bank number 2 can seek a deficiency judgment, right? The bank number 2 can go seek a deficiency judgment, but they don't get a penny of the 100. Yes, Stephen.
So to offset this risk, are the interest payments generally higher, or how do they?
Okay, so why would you give someone a second mortgage? What you're asking, right? That's a good question. Generally, banks don't do that, right? It's I don't say dumb is the wrong word. It's not a prudent thing to have to be a second fiddle, so to speak, to be the second mortgage, right? I'm sure some banks will do it. Maybe they'll charge a higher rate or charge a higher rate, but it's risky because if there's a foreclosure, you might walk away with nothing. Good question.
Doesn't it have a lot to do with the creation of like CDS and default swaps?
Oh, we'll get there in a minute. We'll get there in a minute, I promise. Okay. Now, the courts actually enforce these sort of deficiency judgments very rarely, right? Courts don't like enforcing them. They're very unpopular. Okay. All right. Now, Dakota mentioned, what'd you say? Yeah. If you were paying attention in the late 2000s, 2009, 2010, you may remember we had something of a real estate crisis. It would be impossible for me to summarize in a single class why that happened, but I'll try to do my best to explain some of the factors. Over the last several decades, the federal government adopted many policies to encourage home ownership, which sounds like a good thing. Some of these policies encourage lenders to give loans to people with low credit, right? This was called subprime. You can have prime credit, or it's below prime credit, you have subprime credit. Generally, banks would be hesitant to give loans to people with bad credit, but the federal government said, don't worry, we will guarantee it. So if the buyer defaults, the government backs it up. So the banks were risky in giving out these mortgages. The banks experimented with different types of loans. Traditionally, most loans required you to put down 10 or 20%, and maybe you had a 30-year fixed-rate mortgage. But to entice people, banks said, okay, 0 down. You don't have to make a down payment. But instead of having a fixed-rate mortgage, you have what's called an ARM, an adjustable rate mortgage, where maybe you start like a 3% and you shoot up to 18%. And a lot of people said, aha, this is great, right? I don't have to put any money down, I buy a house. So people would buy a house with a very low mortgage. And then before they knew it, they were facing high interest rates. Compounding this problem was that the price of real estate began to drop. For many years, real estate was going up and up and up and up, and then suddenly dropped. And people would be in a house that was what's called underwater. What does that mean? They owe more on the house than it's worth, right? They maybe bought it for $200,000. Now the house is worth $100,000. They can't sell it because to sell it wouldn't even pay off their mortgage. They're stuck in houses. Then what happened? People started walking away from their mortgages. Think of like Mr. Robinson, right, in Dallas. It was cheaper just to walk away from the house and to pay a mortgage payment at a higher rate they couldn't afford. So there were a lot of foreclosures. Compounding this problem even more is that a lot of banks began to sell mortgages, right? The same way I can buy a share in Google or Microsoft, you can buy a share in Josh's mortgage. In fact, I'm certain that my mortgage has been chopped up. It's what's called securitized. You chop them to securities. As a result, you had all these people who were investing in these mortgages, and all these mortgages were failing, and they were going into foreclosure. So huge chunks of the economy started collapsing. On top of that, there were very low interest rates, which encouraged buying. So there was like a perfect storm of bad stuff that happened. And in the 2000s, 2006, 7, 8, 9, 10, there were these massive foreclosures, and mortgages went crazy. One second. Things, I guess, maybe have stabilized. I don't really even know. But this was a huge issue that resulted in a lot of people losing their houses. But also many of those people had engaged in reckless behavior, were buying houses they couldn't afford with nothing down. So I'll let you judge. Yeah?
Didn't they also, and I could be wrong, bundle a bunch of the high-risk mortgages into
Yeah.
other ones?
Yeah, so the word he used was bundling. So basically you would invest in subprime mortgages chopped together. And the reason why these are considered good investments is that the federal government backed them. But then Fannie Mae went under and Freddie Mac went under and all these entities failed. It was a disaster. It was bad. Thankfully, I didn't buy any property then, so I was fine. But a lot of people at the time would say that property is the best investment. It's always going up. It'll never go down. And that's not ever the case. Things always go down. Nothing solid. Want to raise your hand? Yeah.
I was going to say the banks thought they were hedging against the risk back in the credit default swaps, but that exacerbated the issue because the insurance couldn't pay out on those as the default started to.
Yeah, and then companies like AIG and others went under, and a lot of these institutions just failed because they were so heavily invested in these what were called mortgage-backed securities. They were securities that were backed by mortgages, and then when the mortgages failed, it was bad. It was bad. There's an entire chapter in your book which I no longer assign. I used to assign it, but it's past. These sorts of things aren't as relevant now as they were a couple years ago. All right, any other questions on that? All right, who's next? Courtney. Let's do the second case, or I guess the last case, which is Murphy versus FinDev Corp, New Hampshire, 1985. Want to give me the facts here, Courtney?
The mortgagor defaulted on his obligation to the mortgagee, and his house went under foreclosure. And so the mortgagee went to sell the house, but there was a conflict of interest that arose because the mortgagee ended up being the one who bid on the house.
Okay. Well, just walk me through the facts of like how the borrower fell behind on his payments and what happened. Just walk me through the details, please. You're exactly right, but I want to walk through how they fell behind their payments.
There were a bunch of he lost his job and then couldn't pay.
Yeah.
And then he defaulted and couldn't pay the fees associated with the proceedings.
Okay, very good. This is an all too common story, right? The plaintiff took out a mortgage, he got his note. He lost his job. He fell behind on his mortgage several months. The lender gave notice that they were going to foreclose on this property. The plaintiff made some efforts to foreclose. He paid the arrears, but didn't pay the costs and fees. Why would he pay one, not the other? He may not have even known what the fees were, right? It's not in the case, but it's possible he was never even aware what the fees were. We don't know for sure. Foreclosure sale was scheduled. They put all the notice out there. They delayed it, And the bank says, fine, we'll delay it, we'll put $100 cost. Now the bank knows he's not going to come with the money, and this is just piling cash upon cash. Eventually, they tried to postpone it further, and they couldn't. And the sale was held. All right, Josh, who was present at the auction?
So the plaintiffs, representative of the lenders, and an attorney who had been engaged to conduct the sale because of the lender's attorney. I guess couldn't make it there because of the bad weather. It snowed.
Okay. How many bids were placed here?
Just one.
Okay. And who put the bid in?
The attorney.
For
the lender.
the bank.
Oh yeah.
Yeah. So basically, who was running the auction? The bank. Who put the bid? The bank. And Josh, how much was the bid for?
$27,000.
And where did they get that number from?
So that was, I guess, the amount left.
Good.
They had to
Yeah.
cover.
So again, this mortgage had some equity in it. You know, in other words, the plaintiffs had paid off some of their mortgage, but not all of it. And the 27 basically brought the number down to zero. Right? That was the amount of money that was owed to the bank. Now, Javier, why do you think the bank bid $27,000 exact? You know. Yeah, because they had lent $27,000 to the buyer, and they didn't get that back. So they basically put whatever in that they were owed. Right? So the bank took a loss on this property, right? The bank took a little bit of a loss. But then what did the bank do the next day, or at least a couple days later?
Well, they contacted, they were in talks with another buyer who put in a higher bid.
How much was that other bid?
Well, it started off with, they offered to buy it at 27.
Nope.
And they
Yeah.
countered at 40, and they settled at 38.
Now, why do you think the offer was 27 initially?
Because that's how much the bank paid for it.
Right. So the other guy said, "Hey, look, I know as a matter of public record, you just bid $27,000. I'll take everything for 27." The bank says, "Nuh-uh, we want more." And negotiated back and forth, and they put down to 40. Then went down to 38. That was the purchase price. So in the span of like what, a couple of days, they made 11 grand, right? The plaintiff sued, and he looked to set aside the foreclosure sale. Now, he didn't seek an injunction to block the sale, right? He could have done that, but he didn't. Instead, he set to set aside the sale, right? Is that Lauren? Lauren, you want to walk me through the court's opinion, please? Majority.
They ruled for the plaintiff.
Okay.
That the lenders failed to exercise good faith and due diligence.
Okay, so there are these duties, right? They're the duties of good faith and the duties of due diligence. I mean, you probably have seen these terms in contract and some other classes. Lauren, does the court find there's a violation of the duty of good faith here?
Sorry?
Does the court find a violation of the duty of good faith? In other words, did the lender here act in bad faith?
No.
Okay, tell me why.
They said that the lenders complied with the statutory requirements of notice and property. They postponed the sale one time, do not bid with knowledge of any immediately available subsequent purchaser.
Good.
And there's no evidence indicating intent on the part of the lenders to injure the mortgagor by discouraging other buyers.
Okay, very good, very good. The duty of good faith is serious, right? When I say the person acted in good faith, that means they weren't acting wickedly, right? They weren't trying to injure the plaintiffs. And here, there's no evidence they were trying to injure the plaintiffs. They were accommodating. They agreed to postponing. They agreed to work at a payment plan. They tried to do stuff to keep the guy in his house, right? They didn't like say, "Ha, we're going to screw them and we're going to hold this sale and not tell anyone." They had notice. They put the advertisement in the post office, right? They did all the things that one would do in order to have a valid auction. So in other words, everything leading up to the auction was fine. The problems arose at the auction, right? Everything up to the auction, they played it by the book. They did just fine. But at the auction is where things went bad. Is that Jasmine? Jasmine, what happened at the auction that the court found was so problematic?
That the only bidder was the lender.
Okay, and what else is problematic about the auction? Okay, how do we know that? How do we know that there was no way of getting the equity back? What about the single bidder was problematic? What's like the evidence that the court considers? Well,
I find that it was problematic that they didn't like advertise it to the public, and they didn't
what did the plaintiff want out of this sale? What would he want to happen, Jasmine? And what would that have required? Yes, they wanted a higher bid, right? The objection with the bid was too low. The objection with the bid was too low. The plaintiff wanted a higher bid. But we know that the bank was the only bidder, and the bank bid exactly $27,000 because that was the amount that was owed. So the court finds that they acted in good faith leading up to the auction, but they did not comply with the duty of fair dealings, right? Katie, what is this duty of fair dealings, and how does the court define it? I'm sorry, due diligence. I'm sorry, not fair dealings. It's the same thing. Due diligence. I used the wrong word. I'm sorry.
Or whether a reasonable man in the lender's place would have.
Yeah, right. In other words, pretend this wasn't the bank, right? Pretend that this was a reasonable person selling the property. If a reasonable person was selling this property, what steps would they have taken to get a higher purchase price?
They would have like advertised or tried to get more people.
Yes. And what happens if you're selling your house, Katie, and only one person shows up to bid? What would you probably do?
I guess you could sell it to that person.
Do you have to accept the offer?
Or hold on to it.
Hold. Schedule another auction. Right? You schedule a second auction. You might also have what's called a reserve price. With a reserve price, you say, look, we're going to accept bids, but nothing less than X. Right? So you ensure that any bid will at least cover some of the equity. So here the court finds a violation of the duty of due diligence. I'm sorry, I said fair dealings. It's the same thing, right? You have 20 words for the same thing. But you have a duty of due diligence. And because the bank failed to comply with the duty of due diligence, what's the remedy, Katya? What's the remedy?
They said that the formula is used to measure where the bad bank was from.
Okay, hold on. Do they cancel the sale? In other words, does the guy who bought it for $38 lose the property? Do they set aside the sale? Yeah. Okay. What is the plaintiff actually getting after? Does he want his house at this point?
He wants the money, like some money back.
He wants to get back some of his equity. He put all this money to his house. He wants the money back. Okay, so Katya, what's the formula the court uses? And this is a little bit confusing. We'll try to do our best here.
So it says that the damages is going to be based on the fair market value, a figure in excess of the fair price, and then it would literally induce mortgagees to perform their duties properly at a fair price.
Okay, very good. The court puts over this formula, right? The formula is the difference between the fair price and the price obtained at the foreclosure sale. The difference between the fair price and the price obtained at the foreclosure sale. Now, Tyler, walk me through this. What does fair price mean?
So it looks at the specific sale as opposed to the entirety of a market, such as fair market value. So when a mortgagee uses due diligence, and that's amount outstanding, equity, advertising, all of the factors considered, what is a fair price for this specific property as opposed to an average, like a fair market value?
Okay, so Lon, let me ask this question. How do you distinguish fair price and fair market value? How do you separate these two concepts? What's the difference?
One
No,
instance.
yeah.
So fair price will be looking at specific circumstance condition
Uh-huh.
to the sale. Fair market value would be similar property in a similar neighborhood.
Okay, but how do you know what the fair price is without looking at what properties are sold nearby? Yeah, it's a hard question, right?
For example,
Okay, I asked you an unfair question. I don't really know the difference myself. I teach this case every year, and right? How would you come up with a fair price unless you know what similar properties in the neighborhood were sold at, right? For example, if I want to work for the county and I want to assess an appraisal for what my house is worth to property taxes, right? I'm going to look at, okay, what were the houses in that block sold for, right? Similar size, similar age of the property, right? I think both Tyler and Lund gave, I think, fair answers about what fair price and fair market value. I guess the fair price might be a little bit lower, right? Because even if the fair market value is 100, maybe on this day after the snow, you only get 90, right? Maybe there's circumstances that say, this was a rough time of month, people were out of town for Christmas, whatever, right? Okay, 90 sounds fair. So I think the fair price is something less than the fair market value. How much of that difference is, I can't tell you that. But I think at a minimum, this fair price is lower. So let's just say in this case that, the property value is 27, and let's say the fair price was 90, right? That means that there's roughly $60-something thousand the bank has to pay. But we actually have evidence of what the fair price might be, right? I'm sorry, name tag over there, I can't see it. Just tell me what's your name. Robert. What's our best evidence of the fair price in this case? We have some evidence.
Probably the second sale.
Yes. How much was that for?
$40,000.
Well, what did they actually agree on here? You're in the ballpark.
38.
Yeah, 38. Thank you, sir. So we know that I think 38 is probably a good guess what the fair price is. So then what would the measure of damages be, Robert? If the sale brought in 27, and we know that the fair price is 38. Well,
The difference between the 38 and the 20.
which is?
11.
Thank you. Yeah, law students hate math. I know. There might be math in the exam. Just don't wince. But you might have to subtract two numbers, right? 11. Yeah, I know. 11 every year. 11,000, which means the bank pays the plaintiff 11 grand, which is effectively their unfair gain, right? It's how much more did they gain that they shouldn't have gained? Because these guys were jerks. They came around, they bought it, they sold it the next day for $11,000 more. And the bank knows that too. The courts are very sensitive when they sense that one party is taking advantage of another party. So this wasn't bad faith, but they deliberately sold it and then turned around the next day for 11 grand. So the formula the court puts forward means that that $11,000 goes to the plaintiff. Now, is that Chris? What do you want me to call you?
Chris. Sorry.
Chris. Okay, Chris. That's fine. Whatever you want me to call you, I'll call you. I don't really care. Chris, what about attorney's fees in this case? Yeah, what about attorney's fees? I always tell my students this. What's the most important rule of being a lawyer? Most important rule. Get paid. Not Rule 11, right? People always say Rule 11. No, it's not Rule 11. You'll never see Rule 11 in your life, God willing. The most important rule of being a lawyer is you get paid. And it's even better when the other side pays your bills, because that means your client gets reimbursed.
Yeah, in the last paragraph, it says, on part of the lender, you see no reason to spread my general rule that the conveying litigant is not entitled to collect these fees.
Okay. So the lower court, which is it's called the master, which is basically like a trial court judge, think of it. The lower court assigned fees and said because of the bad behavior of the lender, they have to pay the plaintiff's fees. The court says no fees. So, Chris, do you think the attorney's fees to litigate to the New Hampshire Supreme Court were more or less $11,000?
Less.
Whoa. You got to check your billing, my friend.
No.
To litigate a case to the state Supreme Court is more or less $11,000.
More.
A lot more. So I think the plaintiff got nothing, right? He probably paid more in legal fees than he got in damages, right? That's always the risk, right? The lower court awards attorney's fees, and then there's an appeal, and then the lower court throws out the fees. Now, if the lower court agreed, they would pay your appellate fees as well, right? Whatever fees were used to appeal, the bank would pay. So now the bank gave this guy 11 grand. He may have spent $50,000 in the appeal. This is after being foreclosed upon. Now, it's possible the lawyer did a contingency arrangement, which do exist, where they say, look, we'll only pay, we get paid if you get paid. And these are commercials on TV. So maybe the lawyer got screwed. But here there were no fees paid, so he probably got $11,000 and nothing more. Make sense? All right, but this is a rare case. I think the notes make this point. More often than not, courts do not second-guess foreclosure sales. It's very rare. I guess the facts here are just so blatant and egregious that the court set it aside. But generally, the courts defer to these foreclosure sales. Right? There's some tests. The courts won't validate a sale if it shocks the conscience, right? The price is so low, it shocks the conscience. Does this price shock my conscience? Not really. Although I'm pretty jaded, I don't know. Or if the price is grossly inadequate. Is this grossly inadequate? No, it covers the expenses. So I think in most cases this sort of sale would be upheld, but I think the court was annoyed that the guy just sold it around the next day. Okay. Questions on the mortgage case? Yes, sir.
The shocking the conscience of the court, is it only you have to do price, or is there method and manner?
That's a good question. I think it would describe the entirety, because in this case they found that everything leading up to the auction was fine and the auction itself was deficient. In another case, the process leading up to the auction may be bad. Like maybe they didn't advertise it. Maybe they deliberately held it like in an out-of-the-way place in the middle of a blizzard, right? You can think of circumstances that the entire circumstance would shock the conscience, right? You hold the sale in the middle of a blizzard where the roads are shut down and there's only bidders you. Well, no kidding, you won it. So the court can maybe set it aside there as well. Okay, questions on this case? All right, let me summarize a bit and we'll give you a preview for next class. So from today, please keep in mind with delivery the intent question. Are you dealing with a gift that's inter vivos or a gift that's testamentary? And if it's a gift that kicks in after death, you need to satisfy the Statute of Wills. And this is an easy way for me to trip you up on the exam because there's so many close calls about this. Remember mortgagor, mortgagee versus the promissory note, title versus lien theory. Keep those in mind. In our next class for Thursday, we're going to start what's called recording. You always say the deed was recorded, the deed was recorded. That's what this is. And pay very close attention to the chain of title. A to B, B to C, C to D. And there are examples in the book that actually walk through this chain. Suffer through it. Actually try and follow along. Don't just read and say, oh, whatever, Black will cover it. Actually try to suffer through it. Okay, any questions? I'll see you all on Thursday. Thank you so much.